Hi everyone. Today we'll be looking at the first stage of any negligence case in Canada, establishing a duty of care. Was the defendant under any legal obligation to care for the plaintiff's interests? That is the question we ask at this stage. The modern duty of care analysis originated in 1932 with Donahue v. Stevenson. Prior to Donahue, no general test existed to determine duty of care, so cases in negligence could only be made where the common law recognized a duty of care for the specific sort of relationship in which the plaintiff and defendant were engaged. See Winterbottom v. Wright, for instance. The rule laid out in Donahue was concerned with reasonable foreseeability. Lord Atkin explained it as follows: "You must take reasonable care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor." Who then, in law, is my neighbor? The answer seems to be persons who are so closely and directly affected by my act that I ought reasonably to have them in contemplation as being so affected when I am directing my mind to the acts or omissions which are called in question. In Ann's and Merton London Bureau Council 1977, a policy test was added as a step in the duty of care analysis. The Ann's test was upheld in Canada in Kamloops v. Nielsen, with its final form unveiled in Cooper v. Hobart. Here's the test as it exists today. Step 0. Is the situation novel? If not, go with the precedent. Otherwise, proceed. Step 1. Is there enough proximity such that the defendant's carelessness will reasonably, foreseeably harm the plaintiff? Step 2. Should policy concerns negate the duty of care here? What impact would recognizing a DOC here have on society generally? Concerns may include: does this law already give a remedy? Will there be liability to an indefinite class? And, in public authority cases, was this a policy or an operational decision? The novel situation examination is a pretty standard, self-explanatory analogy versus differentiation exercise. We'll start with the proximity step. The best case to help you understand what reasonable foreseeable means beyond Cooper and Donahue is Palsgraf v. Long Island Railroad, 1928. This U.S. case clarifies that if the harm to a person, as an individual or member of a class, is not foreseeable, then you are not liable to that person, even if you were negligent towards someone else and that caused the harm to occur. In their words, is it reasonably foreseeable that D's carelessness could create a risk of injury to P or a class to which P belongs? Watson v. Buckley, Clay v. AJ, and Dobson v. Dobson also provide examples of this principle in action. Palsgraf also provides for an exception. Imminently dangerous activities are undertaken at the peril of the one doing it. I'm too lazy to check whether that's still part of the law today. Let's look at the proximity element now. The concept of proximity is pretty closely intertwined with foreseeability. Proximity is not a strict test. It's more of a broad idea encompassing the various factors we can use to tell how close of a relationship the plaintiff and defendant had. You're supposed to examine whether, considering that relationship, it would be just to impose a duty of care on the defendant. Anything that speaks to the closeness and directness of a relationship is probably a proximity factor. This includes links created by representations, assumptions of responsibility, reliance, and reasonable expectations as per case law. Some policy analysis may be involved at this stage, insofar as they relate to doing justice between the parties at hand. Doing justice to third parties will be considered at the second stage of the Ann's test. Proximity is usually established by fitting the case into a category established by precedent, but new categories can be made. The creation of new proximity types is limited by the need to be incrementalist. So, if you are trying to establish a new type of proximity, you need to analogize it to an existing one. Here's some existing proximity categories you can analogize to: foreseeable physical harm to plaintiff or their property, misfeasance in public office, negligent misstatement or failing a duty to warn, duties of inspection and maintenance for organizations who do these things, and economic loss related to a contract's performance. Lastly, we should take note of the power that disclaimers have over a duty of care. As held in Hedley Byrne and Company Limited v. Heller, 1964, a man cannot be said voluntarily to be undertaking a responsibility if at the very moment when he is said to be accepting it, He declares that, in fact, he is not. This case also provides useful guidance regarding when the provision of information gives rise to a duty of care, especially when said information happens to be inaccurate. Reasonable people make negligent statements, especially in their unofficial capacity. Information spread through multiple people is especially unlikely to give rise to a duty of care, as its originators do not know or control how far their words will spread through others. We will now discuss how the duty of care analysis works in cases against public authorities. The key rule here is laid out in Cooper v. Hobart. From Cooper, it is established that government actors are not liable in negligence for policy decisions, but only operational decisions. The basis of this immunity is that policy is the prerogative of the elected legislature. Thus, the Canadian standard is much more plaintiff-friendly than qualified immunity in the USA. In Hill v. Hamilton, for instance, the police were held liable for damage caused by their negligence in investigating and arresting somebody. The opinion concludes that police are not immune from liability under the Canadian law of negligence, that the police owe a duty of care in negligence to suspects being investigated, and that their conduct during the course of an investigation should be measured against the standard of how a reasonable officer in like circumstances would have acted. Victims of crimes can also sue police officers whose negligent operational decisions allowed the crime to occur. Jane Doe v. Metropolitan Toronto Commissioners of Police, 1988, is a central precedent for this. Here, the police had pretty detailed knowledge of a rape that was likely to occur in a specific apartment building. The police don't warn local women of the rapist because if the media finds out, then the rapist will find out and they won't catch him. The rapist infiltrated an apartment and did exactly what you'd expect. The victim sued the police for not warning her. The victim won here. The Ann's test was applied and foreseeability and proximity were found, establishing a prima facie duty of care. The court found that the police have a duty to protect specific classes of people they should know are at risk. They could have provided warnings in a discreet manner, solving their concerns about the rapist escaping. Even if something was stopping them from warning her, they could have found other means of protecting her. Mooney v. BC confirms you can only sue if you're especially or specifically at risk from a specific person, not if you're just under threat because you're a member of the public. Castle v. Ontario is a pretty clear-cut application of this. You know the guy has been violent to people at home in the past, so if you find him drunk and disturbing the peace in violation of a probation order and then decide to take him home, where he then kills his roommate or something, instead of arresting, you are proximate. The bounds of this have been stretched pretty hard by recent cases. However, Haggerty Estate v. Rogers is probably the most surprising example. A guy calls the police at a payphone to turn himself in, but leaves before they arrive, and the police take no further action. The police knew the guy was dangerous, but didn't arrest him. They are allowing a public danger to roam, and are therefore liable. This decision is based on just, the case where a boulder fell on the highway and hit a car. Geographic proximity is the only thing that indicates the plaintiff might have been the next victim, but it was still enough to establish a duty of care. In Patrong v. Banks, a guy was killed in a drive-by shooting. Apparently, being part of a rival gang, or in this case, even just looking like you are and being carded by police on those grounds, makes you an identifiable potential victim of local rival gangsters, giving the police a duty to protect you from them without negligence. Let us now return to the distinction between policy and operational decisions. The test for the policy-operation distinction is given in Nelson v. Markey. Nelson v. Markey is all about figuring out when core policy immunity applies. Core policy immunity means that decisions as to a course or principle of action that are based on public policy considerations, such as economic, social, and political factors, are not actionable. Whether or not a choice meets this standard depends on many factors. Assessing the nature of a government's decision involves the level and responsibilities of the decision-maker, the process by which the decision was made, the nature and extent of budgetary considerations, and the extent to which the decision was based on objective criteria. The separation of powers rationale animating the immunity guides how the factor weighs in the analysis. CP 488. The more a government decision weighs competing interests and requires marketing value judgments, the more likely separation of powers will be engaged because the court would be substituting its own value judgment. Finally, to be protected by core policy immunity, the government decision must neither be irrational nor taken in bad faith. Ultimately, whether a public authority ought to be immune from negligence liability depends on whether and the extent to which the underlying separation of powers rationale is engaged. Nelson v. Markey also builds on the invitation principle from Just v. BC. In that case, the province was liable for unsafe highways based on lack of reasonable maintenance, because they invited people to come drive on it by building it. Once the plaintiff proves that their case falls under the just rule, the onus is on the public authority to demonstrate core policy immunity to void duty of care. In Nelson, the defendant was found liable. By clearing snow from the parking spaces, you invited people to the parking lot, forcing them to use the sidewalk. They failed to keep the sidewalk safe, though harm was foreseeable. Well, that's it for duty of care. See you next time.